Good morning, everyone. Happy Monday and Happy New Year. This is our first presentation for Century 21. I want to say thank you for taking the time to come on and learn about the Ontario Standard Lease. For those of you who don't know me, if you can head over to our social media, like us, follow us on Facebook and Instagram. I always tend to give updates or do quick videos on what's happening with the landlord and tenancy realm. So again, for those of you who don't know me, my name is Bita Delisi. If you ever have any questions, feel free to get in touch. I'm always quicker via email, but you can feel free to give me a call or shoot me a text. And I'm pretty responsive, and I'd be more than happy to provide clarity for you and your clients where I can. So I won't bore you. Many of you already know me. I'm happy to say that we'll be doing monthly Zooms for Century 21. Tina and I arranged it for the last Monday of every month. So this is exciting. So if you don't get us on one presentation, you can hop on the following month and get us there. For the purpose of this presentation, everything we discuss should not be taken as legal advice. If you do have a question or if you want me to provide clarity on a specific matter, feel free to get in touch with me either after this presentation or give me a call and we can talk more privately about your matter or your client's matter. So many of you know about the Ontario Standard Lease. We're going to be getting into that. We're going to talk about harmful clauses, what you need to know about even Form 400. So let's get into that. And then what we'll do is we'll save the questions for a Q&A at the end. And I'd be more than happy to stick around and answer your questions. So let's talk about the Ontario Standard Lease, because I come from a real estate background. So I know that back almost 20 years ago, when I first entered the realm of real estate, there was no standard lease agreement that agents can turn to in order to draft leases for their clients. It wasn't until April of 2018, so very recently, the past couple of years, when the Ontario Standard Lease was drafted and the province instructed all landlords to use this lease agreement in particular when they were drafting leases. So when the Ontario Standard Lease Agreement is complete, this creates a contract between the landlord and tenant. The Ontario Standard Lease is also referred to as the Residential Tenancy Agreement. However, this lease, the Ontario Standard Lease, does not apply to certain tenancies or special tenancies, as I'd like to call them. And these tenancies are, for example, they pertain to care homes, sites in mobile communities, land lease communities, most social and supportive housing, basically special tenancies with respect to especially government housings and co-op housings. So there are certain special tenancies that the Ontario Standard Lease should not be used because it's not applicable. If you ever come across these type of tenancies and you want me to provide more clarity, again, feel free to reach out. One thing we're going to talk about throughout this presentation is your rights and responsibilities, not just as a realtor, but as someone acting on behalf of a landlord or a landlord yourself when it comes to drafting clauses for lease agreements. Just keep in mind that a lease cannot take away a right or responsibility under the Residential Tenancies Act. So right before I logged in on this Zoom, I had an agent call me and say that, we sold the property. The buyer agrees to assume the tenant, which is fine because the tenant didn't want to leave because of COVID. So all the parties agreed that the tenancy will be dissolved, will come to an end in May of 2022. So it's about a year from now, a year and a half from now, I would say. However, he wanted to get the N11 agreement to end the tenancy signed now. Well, just because you sign it now, it cannot take away their right to change their minds in a year and a half. So remember, a lease, even if a clause is drafted that the parties agree to such and such on this date, and if it's, I would say, more than 120 days far out, it can be challenged at the board. So remember, a lease cannot take away a right or responsibility under the Act. The Ontario Standard Lease and what happens if a copy is not provided to a tenant. So no different than an agreement of purchase and sale. Any legal document or any document signed by all parties, you know where the acknowledgement is on the agreement of purchase and sale, right above the commission trust signatures on the signature page. Well, when that acknowledgement is signed, all parties are saying that they have received a true copy of this agreement. So again, there is no such acknowledgement in the Ontario Standard Lease. However, the law says that a landlord must give the tenant a copy of any written lease within 21 days after the tenant signs it. The lease should not contain any terms that are inconsistent with the act. And when I mean inconsistent with the act, I mean terms that are not parallel to the Residential Tenancies Act. And we're going to talk more in detail about these inconsistent terms, and more specifically, harmful clauses. So if a lease does contain a term that is not parallel with the Residential Tenancies Act or is inconsistent with the act, that term will not be enforced by the Landlord and Tenant Board. So, for example, many of you already know this, that if there's a clause in the lease that all parties agree to no pets in the premises, well, the law says that pets are allowed. So that means this term or this clause is inconsistent. So unless that pet is causing some sort of a damage to the property, or the landlord lives upstairs and is allergic to this pet, then a legal termination and an enforcement of an eviction cannot be followed through the Landlord and Tenant Board. Let's talk about Form 400, because when I started my career in real estate, Form 400, or the agreement to lease, was what I turned to in order to draft leases. This is what realtors are familiar with. However, the brokerage requires Form 400 in order to satisfy certain requirements of RICO, because when RICO audits the brokerage and when they pull up residential lease files, a requirement to completion of that file and the release of that commission to the agents is that they need to have this agreement to lease, Form 400, in their file. Well, Form 400 now is not a lease agreement. This is an offer to lease, and it's similar to the agreement of purchase and sale. I would recommend that any schedules or appendices or anything you want to include as in addition to the lease or the house rules, it should be attached to the Ontario Standard Lease. The only thing you should be attaching to Form 400, because it's an offer to lease, are any conditions. Okay, so a condition could be the tenant agrees to provide a credit check satisfactory to the landlord. Those type of conditions, those should be attached to the agreement to lease, Form 400. I'm not really a fan of Form 400, and the reason why I'm not a fan is because Form 400 was drafted by lawyers who did not really understand the Residential Tenancies Act, or they were not well versed with the Residential Tenancies Act. And we're going to dissect Form 400 a little bit. More importantly, OREA's old agreements to lease were referred to as hybrid documents. And a hybrid document is basically an offer document that turned into a lease agreement only upon acceptance by the landlord and tenant. So, which was Form 400. So unfortunately, realtors prior to 2018 did not have any specific form or offer to lease. And that's why Form 400 was used. Realtors didn't have a choice but to use this Form 400 as an offer to lease. Form 400 did not comply with the Residential Tenancies Act. This is why I'm not really a fan of it. It didn't contain legal clauses that are required in order to protect the parties. This is why realtors resorted to drafting these legal clauses. Now, we're going to talk about clauses, especially harmful clauses. And I do understand that, as realtors, you do leases as a favor, because let's be real, there's not really enough commission attached to doing a lease, but realtors do it as a favor in order to keep that relationship with their client, hoping that they would use them when it comes to purchasing or selling additional properties. So hence why the Form 400 was used. This offer to lease, Form 400, became an agreement to lease once it was signed and executed. So prior to 2018, Form 400 was the lease agreement. Now it's just the first step to signing the Ontario Standard Lease and entering into the residential lease agreement. Now, Form 400, and I mentioned in my previous slide that it didn't really have clauses drafted. That's why, in addition to signing it, even though there are some built-in clauses, which we're going to dissect, other clauses or other house rules had to be drafted by realtors, who again drafted these leases in good faith in order to, keep that relationship with their client. However, even though the intention of the realtor, you come from the right intention, is to protect your client, some clauses drafted by realtors can actually end up doing more harm than protecting the client when it gets to the residential, when it gets to the landlord and tenant board. For example, some of these clauses that are drafted by realtors, and what I'm seeing lately is, for example, the tenant has the right, if in good standing, to automatically renew the lease term in perpetuity. So just keep this clause in mind, because we're going to dissect it in another slide throughout the presentation. The second clause is the tenant agrees not to smoke in the property. Well, that's fine. Even if the tenant agrees to it, how can you enforce it? Unless they are interfering with the landlord or another tenant's reasonable enjoyment. Or number three, the tenant agrees not to have any overnight guests in the property. We know, again, even if the tenant agrees at the time of signing of the lease agreement, that there's no way that a landlord can really evict because the tenant has a guest. So let's get our feet wet with Form 400 a little bit more. So here's other things that are wrong with this form. So clause number 4, I know that 9 out of 10, I would say 99.9% of agents have not really taken the time to read Form 400. So we're going to dissect it a little bit. And I want to make sure that you understand what it is that you're getting your clients to sign, because what happens is sometimes a client comes to me, brings this form and says, I signed this, but my realtor didn't explain. And now you have a complaint against the realtor, and now you have a complaint against the opposing party at the board. So clause number 4 in Form 400 asks for the first and last month's rent up front. This is important for you to know when the offer is accepted. So if you look at what the clause says, the deposit and prepaid rent, the tenant delivers upon acceptance by negotiable check to the listing, usually the listing brokerage's trust account. The deposit in the amount of, let's say, $5,000 this is the important part, as a deposit to be held in trust as security for the faithful performance by the tenant of all terms, covenants, and conditions. Now, here's what's wrong with this clause is that it is illegal to take the first month's rent before the first month arrives. Okay, so before the first month of tenancy, it's illegal to take first month's rent. However, I do understand, and I do recommend that this is common practice to collect the first and last month's rent. It is a good idea, and I do recommend it to my clients. So just keep this in the back of your head. We're going to come back to it in a minute. Okay, the description of the premises in Section 1 is not sufficient. So as you can see, I've taken a screenshot of the premises. It asks for the address of the premises, but really there's no description of what exactly is being rented. Is it a room? Is it a unit? Is it an apartment? Is it a suite? Is it a basement? What is the tenant renting? There needs to be more detail and clarity as to the exclusive use of the premises. This is really important because the reason why it's important is because of the service for notices. The address of the rental unit has to be very clear, because in the event that either the board needs to serve notice to the tenant, and the tenant, let's say, for example, the tenant resides in the basement and the premises it's written out as for example, 123 Sesame Street, and there is no basement mentioned, how is that tenant going to be notified of any legal notice? So we're going to come back to clause number 4, which is still troublesome. The last month's rent deposit per the Residential Tenancies Act is not as stated a deposit as security. Okay. The last month's rent deposit is security as rent and has to be applied to the last month's rent. So remember when I mentioned that these clauses were drafted by realtors, not by realtors, sorry. These clauses were drafted by lawyers who were not very well versed with the Residential Tenancies Act. So here's why it's harmful that it's outlined this way, and it states that it's held as in trust as a security, basically as a security deposit, which is an illegal deposit. So by OREA describing it incorrectly in Form 400, the court or the board may decide that it is actually an illegal deposit and that the landlord will have to return it to the tenant if the tenant changes their mind about moving in, even after the deposit is accepted. This is why this clause is very troublesome. Now, I've reached out to Uriah back in, I think it was late September, beginning of October, with respect to putting together a team to review and revamp Form 400, because there's a lot of issues with Form 400. And I mean, it could be because of COVID that no one has gotten back to me, but hopefully I can get in touch with someone and we can revamp these forms. So again, this could be an illegal clause because it actually states that the first and last month's deposit is required up front and that it's put towards a security deposit based on the faithful performance of the tenant, which is illegal because the only deposit that a landlord can obtain is a first and last month's rent to be applied to the first and last month's rent. Clause number 5 actually misstates the law and indicates that only people listed in Form 400 can live there. As you can see, clause number 5, the use, it states that the tenant and the landlord agree that unless otherwise agreed to herein, only the tenant named above and any person named in the application completed prior to this agreement will occupy the premises. So, for example, if the tenant gets married, if it's a single tenant and they get married and their spouse wants to move in, basically Form 400 says the spouse cannot move in and live there and spend the night, which is not allowed. So occupants, there is no, Form 400 doesn't make reference to occupants. Occupants would have to be listed in a schedule or in an appendices. Occupants, however, are not tenants. So they are people who live with the tenants, such as the children who can't be listed as tenants because they are minors. So occupants are not tenants, and it's actually up to each tenant to decide who can visit the property. Obviously, subject to adjustments, subject to property standards, bylaws, and condo rules. So keep that in mind as well. Clause 14. Clause 14, with respect to access, attempts to provide the landlords with a right to enter the unit for various reasons. So I'm going to tell you why this clause is illegal. This clause is illegal because as entry is permitted only in accordance with the Residential Tenancies Act. Landlords can access the unit with 24 hours notice, as you know, 24 hours notice, written notice, obviously stating the reason for the entry, the time of the entry, and who will be entering the unit. Well, this clause says the landlord has the right at reasonable times to enter the unit and show the unit, which is not parallel to the Residential Tenancies Act. Clause number 21, where this is the signing page, commissions payable to the brokerage. This agreement, so Form 400 is between the landlord and the prospective tenant. However, this clause states to bind the landlord and has them agree to the brokerage's commission may be deducted from the deposit. Well, the brokerage is not a party to the agreement. So who is the landlord agreeing with exactly? Is it the tenant or is it the brokerage? The tenant is not a party to issuing commission, and the real estate brokerage is not a party to the lease agreement. So this clause is actually not only misleading, but it causes confusion when the tenants come to sign it or when a guarantor is added to signing it. So I basically dissected Form 400. I hopefully it opened your eyes to what it is that you're getting your clients to sign and why OREA should open their allow for this Form 400 to be revised, because there are a lot of things that are outdated and there are a lot of things that are not parallel to the Residential Tenancies Act. So the Ontario Standard Lease is required to be attached to Form 400 for the brokerage to release commissions. When the Ontario Standard Lease is signed, this becomes the lease agreement in its entirety. So what is the difference between Form 400 and the Ontario Standard Lease Agreement? So here is the differences. Form 400, as mentioned, is an offer to lease and is usually the first step in leasing a residential property. Again, Form 400 should not be used for commercial agreements, commercial tenancies, totally different forms. Form 400 may be subject to conditions that need to be fulfilled. So remember when I mentioned, if you have any conditions, whether it's the tenant's son wants to see the property, or they need to confirm with management if pets are allowed, or if they need to verify their credit rating or their credit review by the landlord, these conditions should be attached to Form 400. And Form 400 is signed first. Upon the execution of Form 400, the Ontario Standard Lease Agreement is drafted. So one of the questions I get asked a lot lately is, who drafts the Ontario Standard Lease? There is no law that references who drafts this lease agreement. However, what I ask is, whose property is it? It's the landlord's property. I would recommend that the landlord drafts the Ontario Standard Lease so that the landlord knows exactly what is in the lease. The Ontario Standard Lease is more detailed. Of course, it's longer in length, and it replaces Form 400 once it's signed. So again, the Ontario Standard Lease came into effect on April 30th, 2018. The revised Ontario Standard Lease is effective for March 1st. So this is the new forms that you should be using. And once the presentation is done, I will also attach it in the chat, so as a PDF, so you can download it along with a copy of this presentation. And I will send Tina a copy as well, so she can send it to everybody. All residential tenancy lease agreements entered into after March 1st, 2021 must be on the new Ontario Standard Lease form. So the old one that says the Ontario Standard Lease is effective April 30th, 2018, you should stop using it on March 1st. Oh, actually, end of February 28th. So March 1st and onwards, you should be using the new revised lease agreement. The province of Ontario has updated its standard lease form to take into account any changes that were introduced last July with respect to the new Bill 184. So what are these changes? These changes are not significant changes. However, you should know what the changes are in your rental business. So number one, the requirement to save new tenants with the electricity consumption form for sub-metered units is completely removed. So Bill 184 has repealed that requirement. This is really not major anyways, because a lot of your tenancies didn't apply to this, but it's good to know. Number two, in the preamble to the general information section following the signature page, the website for the Residential Tenancies Act and the Landlord and Tenant Board has changed. In Part D, the narrative has added additional grounds for ending the tenancy. So this is good because additional grounds is also disclosed in the Ontario Standard Lease now with respect to ending the tenancy, such as for the landlord's own use or for the purchaser's own use. Number four, the fines payable by landlords who evict tenants unlawfully or give notices of terminations in bad faith has been increased per Bill 184, and it's also disclosed in Part D. This is important as it's disclosing to the tenants that if the landlord serves a notice of termination in bad faith, it outlines what the tenant can do and where the tenant can turn to for advice. In Part I, the narrative has changed to reflect the post November 15, 2018 rent control exemptions. In Part Q, there's clarification in the narrative, making it clear that if a tenant rents the rental unit to a third party, that person is not a guest, and therefore the landlord's permission may be required. This is with respect to subleasing, more specifically to Airbnb or short-term rental type situations. At the end of the narrative, there's a section called the Guide to the Standard Lease, which actually now lists the website in multiple languages. Because there's so many immigrants entering the country and entering into leases, they often are not familiar with the English language. This narrative actually lists their websites in multiple languages of where they can turn to for help. And finally, the document is now 14 pages instead of 13 pages. Let's talk about Schedule A and additional appendices. We're going to also talk about drafting clauses as well. So the provincial government is woefully, obviously, inadequate in terms of providing landlords, more importantly, with the specifics surrounding the landlord and tenancy relationships. They don't have specific schedules or appendices that you can attach to the standard lease agreement. However, the province has allowed for additional terms to be added to the lease agreement in the form of a schedule or an appendix. So at the end of this presentation, there's a downloadable link. Many of you have already downloaded. For those of you who haven't, you can download this link. It sends you a copy of the landlord guide that we've developed that has a Google Drive attached to it. And in that Google Drive, we have updated the Schedule A for your convenience to be used, and you can alter it to basically suit your clients' matters with respect to entering into a lease agreement. So again, I will send that to Tina, and I will attach it to the chat here. Let's talk about rent deposits. The landlord can collect a rent deposit from a new tenant on or before the start of a new tenancy. That deposit cannot be for more than 1 month's rent, and that deposit cannot be used for anything else except for the last month's rent. So it cannot be used as a security deposit. It cannot be held in the brokerage's trust account so that conditions can be fulfilled. That deposit can only be put towards the last month's rent. If a landlord gives a notice of rent increase, the landlord has the right to ask that tenant to top up that deposit by the same amount. What are illegal deposits? So illegal deposits, we're going to talk about key deposits. So illegal deposits are the following: damage deposits, vehicle deposits, utility deposits, pet deposits, repair deposits, light bulb deposits. These are all illegal deposits, okay? And again, any other deposit other than the last month's rent, with the exception of a key deposit, is an illegal deposit. Now, let's talk about key deposits. Why is a key deposit an illegal deposit? A key deposit becomes an illegal deposit when the landlord requests an unreasonable amount for that key deposit. So you can request, a landlord can request a key deposit in the amount for the replacement of the cost of that key, not the locking mechanism, not the garage door remote, not the access fob, not the locker room key, but only the unit key. So often I see a key deposit in the amount of $200, $250, or $500. These can be argued that they're rather an excessive and unreasonable amount of a deposit. And if a tenant brings an application against the landlord at the board, they can request a refund of that deposit. And if the board sides with them, if they agree that that is an illegal deposit, or because it's so excessive, the board can issue an order for the landlord to refund that deposit. So you want to make sure that your key deposits, although they are refundable, that they are a reasonable amount. So rent payment methods. I know that I used to make this mistake all the time when I was drafting leases for my clients. The I would also put in a clause in the Schedule A saying that the landlord agrees to exchange the keys to release keys in exchange for 10 post-dated checks. Well, this was before I got into legal services, and now I know that the landlord cannot require the tenant to pay rent by way of a post-dated check, cash, direct deposit, auto withdrawals, e-transfers. That tenant has to pay the rent in any which way that the tenant feels comfortable with. Um, More often than not, I get landlords who say to me, well, if the tenant can pay in whatever which way they want to pay, what if they don't pay? At least with the post-dated checks, I have something in my hand. Well, here's the thing, is that post-dated checks, number one, they can always come back as NSF, they can always bounce. Number two, if they don't pay the rent via e-transfer any which way they want anyways, those checks that you have in hand could bounce. So it really doesn't matter whether or not you have post-dated checks. If the tenant doesn't pay the rent, the landlord has the right to pursue an eviction through the board. So getting back to the slide, the landlord must provide a receipt for any rent payment or any deposit or any other charge upon request by that tenant. The landlord must provide a former tenant with a rent receipt or any receipt if that person asks for one within 12 months after the end of their tenancy. And the tenant and the landlord cannot charge a fee for providing a receipt. So I just wanted to provide clarity because I get a lot of overwhelming number of calls with respect to landlord providing rent receipts and wanting to charge the tenant 10, 20, $25 for their time in drafting these receipts. So again, usually tenants ask for rent receipts between the months of January and April because it's tax season and they need to provide it to their accountant. So a landlord cannot charge a fee for providing a receipt. Now we're going to get into the more details of this presentation, and this is about clauses. So before we jump into clauses, again, I know that realtors come from good intentions in drafting clauses, but without knowing the consequences of the clauses that you are drafting, you may actually end up doing more harm to that tenancy than you are doing good. I would recommend that any clauses that you draft are done by a legal professional. That way, it is explained clearly the consequences of the clauses, and everybody is on the same page with respect to their understanding of that particular clause. So here we go. Let's talk about grass cutting and snow removal. I'll tell you a little story. When my father-in-law, who is 84-year-old Sicilian man, when he first came to Canada, he purchased real estate. He bought real estate, and he didn't have a lease. It was just an understanding that that tenant took care of the property. So he provided the tools for that tenant to, maintain the lawn and shovel the snow and salt the pathways. Now this was back in the 50s and 60s where, the landlord and tenant board really didn't exist. And landlords had the upper hand in evicting tenants if, they didn't agree with something that the landlord wanted. So gone are those days, because now there are laws that are put in place to protect tenants. One of the laws says that the landlord is responsible for maintenance of the property. Now, the Residential Tenancies Act does not address snow removal or grass cutting directly. However, it does state that it is the landlord's responsibility to make sure that the property is kept in a good state of repair, is fit to live in, and complies with health and safety standards. So the landlord has the responsibility to make sure that the tenant or guests of the tenant or occupants can safely enter and exit the property. This is the responsibility of the landlord. Now, I understand that sometimes the landlord and tenant both agree that the tenant will maintain the grounds and shovel the snow and salt the pathways as long as the tools are provided by the landlord. Now, this is fine if you agree to it. What I would recommend is that this responsibility should be drafted in a contractor's agreement in addition to the lease agreement. You should never include this responsibility in your lease, because in the event that the tenant didn't agree or doesn't agree to continue the service, what would the landlord have to do? The landlord has two options. Either the landlord can come there and shovel the snow and cut the grass, or hire a contractor. By drafting an agreement in addition to the lease, obviously that agreement has to have a compensation attached to it, and it has to be clearly outlined as to what exactly the responsibility of that tenant is for that compensation. The landlord and the tenant can agree to the tenant keeping the grounds clean and shoveling and salting the pathways. Again, I would never recommend that monies be deducted from the rent. You never want to do that. You want to make sure that you're paying for the tenant for this service. Okay, so these two agreements, the lease agreement and the contractor's agreement for lawn care and snow removal, they have to be kept separately. The second clause is everybody knows this one. The landlord does not allow the tenant to have pets. So we know that this is an inconsistent clause with the Residential Tenancies Act. This means that a landlord cannot pursue a termination of tenancy in order to evict that tenant for having a pet through the board. Now, there are some circumstances where the landlord lives upstairs, or the landlord is renting a room and the tenant has a pet and the landlord is genuinely allergic to that pet. Obviously, the landlord has to provide documentation of such allergies to that specific pet or that pet hair. And the tenant would either have to find another accommodations, or they would have to have that pet removed from the rental property. Again, any clause inserted in the Ontario Standard Lease which is inconsistent with the Act cannot be enforced and therefore is void. So even if the tenant and the landlord agree to it at the time of signing, it cannot be enforced. What I do know is happening a lot lately, because I'm receiving a lot of calls from realtors, is that tenants are withholding the information from the landlord. They don't want to disclose to the landlord that they have a pet because they're afraid that they won't get approved for that property. I mean, it's sad to say, but this is what it's resorted to. And this is why an eviction cannot be pursued, because the board knows that the landlords are usually discriminating against those who have pets. So they want to gear away from that. So again, it's an inconsistent clause and it cannot be enforced. So I got a call not too long ago, and it was from a realtor who had sold a property and the new purchasers required vacant possession. Aside from not being able to guarantee vacant possession, because there is no such guarantee to vacant possession, I always ask to review the lease, because I want to see, first of all, if they're in the middle of their lease, then the landlord has to honor the lease to the end of its term. Secondly, what I look for when I'm reviewing leases is this clause. The tenant has the right, if in good standing, to automatically renew the lease term in perpetuity. So looking at this clause, reading it on its face, to me, or to the reasonable person, it's exactly what it sounds like. So the tenant has the right, if they're in good standing. So if they pay their rent on time, if they take care of the property, to renew the lease term in perpetuity. So what is the consequence attached to this clause? Why do I look for this clause in particular when I'm renewing the lease, when I'm reviewing the lease? Well, this clause, when inserted by the realtor, which 9 times out of 10 it is, it can actually prevent the landlord from ever evicting a tenant for themselves, for a family member or a caregiver, or for a purchaser when they sell the property. So in the N12, which is the notice to end the tenancy for the new purchaser's own use or for the landlord's own use, it states on the second page, and again, I know 9 times out of 10, nobody reads the N12. They're so eager to serve it, but they don't know what it says. On the second page of the N12, it says to the tenant, if you disagree with this notice, what you can do if you disagree with this notice. So if the tenant disagrees with the N12, they don't have to move out of the rental property. This is really important, especially if they have this clause in there, because this clause states that the tenant only has the right to renew the lease term, meaning that if the landlord wants to sell the property or move into the property, because the tenant has this right, it is not the landlord's power to do so. It is not even the board's power to do so, because there is actually case law to prevent an eviction and actually persuade the board to dismiss the landlord's application if the property is sold and if the purchaser requires vacant possession in order to move into the property. This clause is a very, very harmful clause. Stay away from it. Do not put it in. This is why I can't stress this enough. Clauses, although you come from good intentions in drafting these clauses, you don't know the consequences and the harm that it can cause when you're called to list and sell the property. Okay, until you're called to list and sell, or until you have a firm agreement of purchase and sale, and you call me and say, hey, Beta, how can we get these guys out? The new purchaser requires it. And I say, hey, Tina, send me the lease. Let me review what the lease says. And I come across this clause. So again, if you're ever unsure of a clause, please get in touch with us. Send us an email. Let me provide you with clarity. Okay, and stay away from drafting harmful clauses. Let's shift our focus from harmful clauses now to the Guarantor Agreement. I get an overwhelming number of calls, again, from realtors with respect to the Guarantor and the Guarantor Agreement. The Guarantor Agreement, it can be attached as a schedule or an appendix, again, to the Ontario Standard Lease. The Guarantor Agreement, you have to be really careful because you have to outline in full clarity what the guarantor's responsibility is with respect to two things. So number one, with respect to the rent, and number two, with respect to damages. What is the responsibility of that guarantor when it comes to those two things? One step further, because occupancy is not a requirement to a tenancy. So because you don't have to live there. So Tina doesn't have to live in a property in order to be on a lease agreement, in order to have a tenancy. Is it a good idea to add the guarantor on the lease as a tenant? So if you're not, again, stay away from drafting guarantor agreements and stay away from Googling and finding a PDF guarantor agreement, because again, these guarantor agreements that you find online sometimes are not applicable to the province, and sometimes they leave things out that, you know, you won't be able to, at the end of the day, you may not be able to hold that guarantor accountable. So you may want to ask yourself, is it a good idea to add the guarantor on as a tenant on the lease? That depends. You would have to weigh the pros and cons of that person specifically. Okay, so we're coming close to the end of the presentation. I will send a copy of this presentation to Tina, and I will also attach it to the chat box. So this is a copy of our Landlord Mastery we've developed, and it gives you access to our Google Drive, which allows you to pull up our scripts, forms, notices of entry. It tells you what questions to ask prospective tenants and how to qualify tenants. I never charge for any of my materials. This is all free for you to download and refer to. You can also send it to your clients. It would be great help to your clients in running their investment properties. And again, absolutely free. So here we are. We come to the end of the presentation. I want to thank everybody for taking the time to come on, and let's open up the floor for Q&A.
Thank you so much for watching. If you like our video, please hit the like button, the subscribe, and even the little bell to get notifications, just so you can stay in touch and watch more of these great videos.